We're not hearing anybody else. Craig, should we be hearing from Commissioner Caldwell at the moment?
It almost looks like it's jammed.
Is this live
Oh,
recording?
there we go. He's it's maybe better now.
Good afternoon.
Good afternoon.
Hello.
Now, obviously the issue we're addressing at the moment is your request, Mr. Gordon, for an adjournment. And you've outlined your reasons for that, but can you just take me through those just for the sake of the record?
Yes, certainly. The first thing is that what's been produced, which you haven't read, is entitled A Summary Statement of Position, Economics, Selwyn District Council. And it's a statement of position by Mr. Derek Foy. Now, Mr. Foy hasn't produced a witness statement for there to be a summary of. What was produced in the Section 42A report was a joint witness statement from a previous hearing on the district plan review. And the joint witness statement was between Mr. Foy and the applicant's economic expert, Mr. Colgrave. And within your own directions, Mr. Commissioner, there isn't any scope for Mr. Foy to now present a summary. But be that as it may, the effect of the summary, which I acknowledge you haven't read, is to reverse the position that Mr. Foy reached in the joint witness statement in the earlier proceeding, which was incorporated in the Section 42A report. And that, as you heard this morning, has caused the author of the 42A report to change his position from recommend to not recommend. All of that, of course, as you saw, sir, occurred after the hearing commenced. There wasn't any prior communication with between Mr. Foy and Mr. Colgrave. We had no warning of what was about to occur. As I outlined in my note this morning, sir, the applicants the applicant's experts had prepared their evidence on the basis that there was a high level of agreement. And so there were aspects and possibly nuances which they omitted because they understood there was a high level of agreement. That appears now not to be the case. And of course, the legal submissions which we provided you with advance warning of with you were also predicated on the same basis. Now, we have, of course, looked at what Mr. Foy is advancing and have considered our ability to respond to that during the course of today in time for a start tomorrow. And in a way that, or can I say that those experts who are predominantly Mr. Colgrave and Mr. Brown, who's seated with me, also Mr. Ford and Mr. Jones, and possibly even the soil and agricultural economics experts, would all like to revisit what they're saying, even simply to check on the nuance of what what they're saying and whether they have covered matters on which Mr. Foy has reached a new conclusion. In other words, Commissioner, we simply haven't been able this afternoon to gather up all of that information and present it to you and to the other submitters in a coherent way. And we would be disadvantaged if that was required of us tomorrow. Ultimately, the applicant is prejudiced. And I probably don't need to say this, sir, but the applicant itself, represented by Mr. Hughes, who is present in this call, has found is finding this effective ambush perplexing and deeply frustrating. I can't add anything more to it than that, other than to say that if we're required to proceed tomorrow, we do so in objecting to the prejudice that arises.
Okay. And so you are seeking another date. And
yeah. Yes. Thank you for reminding me. And we are seeking another date. We've done some internal canvassing about that, and it would seem that the most sensible approach is to look at a date in May.
Okay, I understand that there is time available in the week of the 15th of May.
That,
I mean, don't necessarily need to finalise that now, but
yes.
Yes, I'm also conscious of what's happening in other processes, the DPR, etc. Not that they determine have any determination on my have any relevance to my determination of this issue either. But it's perfectly fine, I understand.
Yes. I think we're expecting to see some decisions out of that process in late July, early August.
Mm-hmm.
But who knows?
All right. Now, I obviously need to think about other parties as well as to whether they will be prejudiced by this. And again, it's occurred at a last minute. But I'd have to reserve leave to other parties too. Well, if we move on, if we're going to that adjournment to a date to be arranged, in terms of evidence that needs to be amended, I mean, you won't be reinventing the wheel in terms of your urban design and all of those sorts of unrelated matters. I wouldn't have thought.
No, I wouldn't have thought so. There's one reservation which Mr. Brown's just reminding me of.
The urban design summary has introduced new information as well.
Yeah. Mr. Brown's just advised me that the urban design summary also received this morning has introduced something new. So we need probably need a new statement from Ms. White.
Well, that would be something that could be dealt with in reply, couldn't it? I can't recall what it is.
Yeah, it probably could, sir. Yeah.
I'm just conscious of not opening up the whole can of worms again, if you like,
Yes.
because we're in a situation where we've had the 42A report, we've had the proponents' evidence, and we've had some submitter evidence. So, in fairness, obviously, if there's going to be further evidence, it's a question of how we deal with that, so that no submitters, for example, are prejudiced by it.
Yeah.
Time frames are reasonably tight.
Yes.
We'd have to, does the scope of submissions and implementers? Because not a lot of them are raised.
In terms of prejudice to other submitters, I'm not sure that other submitters have raised matters of economics or matters that would go to the application of either of the national policy statements.
Mr. Langman does, of course, in his evidence, except he's a planner, not an economist, but
yeah. I wouldn't think he would need to revisit his statement. And I think it's probably from our perspective, and I should have thought of this before this call, and I apologise for that, but I would have thought it's at least Mr. Colgrave, Mr. Ford, and possibly Mr. Jones, and Mr. Brown. So we would probably need those four to revisit their statements and possibly whether they need wholesale rewriting or can proceed by way of addendum. I'm inclined, from what I've read, to suggest that Mr. Colgrave's will need to be rewritten almost from scratch, and I think that's fair to yourself, and to the other submitters, so that it is a coherent piece of evidence. And I think probably the same for Mr. Brown's assessment of the national policy statements and how they apply as well.
yes. Could that be done by way of an addendum? I'm just trying to, or at least something which clearly highlights what is new in there, so that any submitters who are wanting to address it don't have to fish around to see what the changes are, if you like.
Yes.
We've got no evidence in the sheet based on the position, which is now shifted.
Yeah, I know.
Trying to.
That may not be straightforward, is what I'm thinking. Perhaps I can come back to you on that. Or back to the hearings administrator on that. Or even if we could have a few moments just to discuss that suggestion, Mr. Commissioner.
Yes, you can have a few moments to discuss it now if you like. And my critical concern is obviously avoiding prejudice to the proponent, which we've addressed, and also to other participants. There
needs to be clear signposting, doesn't there, as to what people should be reading. Yeah. Perhaps I can just go on mute just for a moment and have a discussion here.
Yes.
I'm obliged. Thank you. Back with you, Commissioner, if I may. Thank you for that. Two things arise. The applicant would want the ability to call a further witness if necessary, by way of review or peer review, and we wouldn't want to lose that opportunity given what Mr. Foy is now introducing. Secondly, in terms of providing addendum to their statements, Mr. Brown raises the valid concern that the evidence becomes less coherent rather than more coherent because of that, because there'll need to be a deletion function and an add function, and it may simply become more confusing for other submitters and readers of a statement. And the preference would be to produce fresh statements, at least from Mr. Colgrave and Mr. Brown. Perhaps in relation to Mr. Ford and Mr. Jones, it's much more straightforward to provide a short addenda by way of amendment. So that's what we would seek, the opportunity to call a peer review witness, at least the discretion to do so, and for Mr. Colgrave and Mr. Brown to be able to file fresh evidence, fresh statements, and for Mr. Jones and Mr. Ford to be able to file addenda.
Right. I'm just concerned about with potential timeframes. I'm concerned about submitters having the opportunity to properly respond without the necessarily the cost of going over the whole thing again. I don't want to prejudice anybody in granting an adjournment.
Well, as I said earlier, I'm not sure that there are any submitters out there who were intending to call economic evidence anyway. And, indeed, no one has offered up any expert evidence on economics other than this last minute effort by the council. So I think the scope to prejudice others is likely to be very small, Commissioner.
Have you thought about a potential timetable?
No, no, I haven't. But ready, willing, and able to do so.
All right. I'll speak to Mr. Friedel now. What would you anticipate in terms of the S42A report?
I guess the first point to note is that it is very much the only points of difference are the economic matters that have been raised in Mr. Foy's summary statement. So the balance of those additional sort of comments in the summary statements were minor in my opinion, and are can be resolved fairly easily. In terms of scheduling, I guess what would be useful is for the economic experts to conference so that the issues can be refined somehow. I don't know if that's possible. But yeah, I probably don't have anything more to add at this stage.
So you wouldn't see the need for a further report?
From
you and from you?
I think I need to feed into the process somehow. So at this point, I'm very much in the air. I've got this new economic evidence that's come through that I've had to put my mind to. Obviously, I need to reach a position for the benefit of the parties in terms of whether I ultimately accept or recommend to decline the request based on the economic evidence that's received. So I think there needs to be a step in there for that.
With respect, isn't that what occurred this morning?
Yeah, but it's still a little bit open in regards to you not being able to present your case in response to Mr. Foy's position. I'm conscious that we don't want to keep going around in circles with this either.
No, that's right. I don't know whether it calls for a full new Section 42 report. I think that would just be unnecessary and would not benefit anybody.
So I agree.
Is what's being suggested, if I can come in here, is what's being suggested that there might be some joint witness conferencing before an addendum to the Section 42A report is written. Is that what you have?
I think that would be helpful from my perspective, just so that I'm clear in terms of what the key outstanding issues are, whether some matters can be resolved. I know that's what the joint witness statements for the other process were. That was the purpose of that process, but unfortunately that sort of carried over into this process and very late in the piece as well.
I mean, I'm conscious of my duties in terms of avoiding unnecessary delay, but I'm also very conscious that this is a point that does need to be properly addressed. Mr. Gordon, did you have a view on directing conferencing? I mean, if you're looking at getting a peer reviewer involved, then we're ending up on a bit of a
I just thanks, Mr. Commissioner. I just didn't want to preclude that opportunity. Look, last time the economists sat down together, they made good progress. We're happy to be involved in that again. I don't see why that couldn't happen sooner rather than later, and then on receipt of that, Mr. Friedel could revisit his conclusions. And then at least we all know where we stand heading into a hearing.
Okay.
We'd also, if I can just finally say, if we're heading down that track, we'd like some directions from you, Mr. Commissioner, that prevent this occurring again. It needs to be clear, I think, to the council what its role is in terms of providing evidence to the hearing.
Yes, I'm not sure what a direction along those lines would look like, really. I mean, I've got to rely on the reporting officers to.
And there is one other thing. I'm sorry to say that again. There's there's a report by Mr. Foy's firm that is known as the
Selwyn Capacity Growth Model.
Thank you, the Selwyn Capacity Growth Model, the SCG. And this hasn't been published in any way. It's just been spoken of, and but Mr. Foy seems to be relying on it, and the core data hasn't been made available publicly, and we need the council's cooperation in that regard.
I'm not sure what the status of that document is.
Well, it's been written by Mr. Foy's company for the council. The council have received it, but it's referenced in Mr. Foy's summary now, but it's not on a website, or it's not available to us for Mr. Colgrave to take away and assess.
All right. Did you have some comment on that? From your knowledge?
That was, sorry, but that was finalised last week. So I don't see.
You can't hear that.
We can't hear that response, sir.
Sorry. Apparently it was finalised last week. Is that a yeah? Is that a public document at this stage or not?
Should I come down and do
That was referenced in the joint witness. That was what was introduced in the joint witness statement.
Yes.
Well, what one option would be if it's not, for that to be produced as part of the part of the preparation for the joint witness conferencing.
Yes. Well, look, it's been mentioned before in the previous round of joint witness conferencing. So the suggestion that it was just finalised last week, I mean, we find that perplexing. But, you know, we've asked for it before, sir, and we've just got to have it if we're going into this without one arm tied behind our back.
Well, I'll have to, yeah. In the back of my mind, I'm thinking that it may have been made available to another economist in another hearing, but I can't recall. But I understand your point. Yeah, and you might just have to leave that with me. But at worst, I would imagine that that would be made available for the purposes of conferencing. If there are any issues with it in terms of whether it's ready for release, etc., you know, so that it remains for that, remains available to the witnesses on that basis. But I simply don't know at the moment what the status of that is finally. So I'm a bit loath to make a direction that it essentially makes it a public document if it's not.
He signed up to the code of conduct.
Well, I'm not sure where that gets us, Commissioner,
No,
but
I'm not going to be making a direction at the moment. So
right.
I will be provided and it'll have to be in a, you know, in a public manner, that some advice as to where that sits at the moment, that document, because if it's one that's not adopted by council, for example, it's not, you know, it may have some value, but it's not not a critical document. If you're not a yeah, that would go to its weight. Yeah, I just need to think that one through.
Thank you.
I do recall that it has been provided before to, or a draft of it anyway has been provided before to an economist, but I just can't be sure of that. Anyway, that's a matter. You've made your request in that regard. Yeah, I am conscious of getting on with this thing and getting it getting it resolved. So that's, and in the end, that's, I have those duties, but I'm also wanting to make sure that I'm fully and properly informed. So, that matter is something that may be able to be resolved directly without my involvement as to whether that's a public document which is available or not. It may not need a direction from me, but I can, that's just uncertain at the moment. But in terms of evidence, I tend to the view that the 42A officer's report won't need to be altered to any great degree, and I don't want to get back into timeframes where that has to be 15 days before and then 10 days and then 5 days, etc., because the time that's not a hearing that can be put off into the never. Although ultimately I suppose that's your client's call. So I don't expect that you would need to prepare a new S42A report. Perhaps an addendum might be helpful, so that you have that in advance, Mr. Gordon, rather than having it being addressed in the reporting officer's time. Although, of course, you have the opportunity to reply to that, but I don't think it did. I don't take it as needing a full new Section 42A report. Did you have a view on that, Mr. Gordon?
No, I don't have a contrary view on that. I agree with you. It doesn't need to be, but I do I do think it would be useful for the economists and the planners to conference before the addendum to the 42A report is finalised.
All right. Well, what if one of the other, or the other planner wishes to be involved in that conferencing process? How would they participate?
You'd have to turn up in person.
Yeah, well, I imagine he'd have to turn up in person in the usual way.
But in terms of being informed,
It's his job.
being properly informed, is there anything that needs to go prior to that conferencing?
Well, I think the order that things have to occur in is that the SCG, not the Sydney Cricket Ground, has to be released, at least to the economists, if not publicly released. Then the economists need to get together and see what they can agree on in relation to it. And then if they produce a JWS, then the planners can look at that and see what they agree on. And all of that could happen during April. And then Mr. Friedel could write a short addendum to the Section 42A report. We can produce statements of evidence at least 5 days, maybe 10 days before the hearing, and get on with it.
All right. Okay, I'll consider the directions. I can confirm that I will grant the adjournment, and I will issue a minute with some timetabling directions in that. If there's, and I'll reserve leave to any party to address me or by way of memorandum if there are any issues arising from that. And then we'll start, I'll leave it to the hearings officers to start looking at potential hearing dates and similar, but that week of 15 May seems to be available, at least from my perspective.
And mine.
All right. Okay, so I've considered all the matters that you've raised, and I have considered the efficiency, and I have considered the fairness, and I'll issue a minute confirming my decision and the directions that follow.
Thank you very much, Commissioner.
All right. Thank you all.
Thank you.
We'll adjourn.